Now, even though the title is termination, I want you to think of any form of discipline, any form of response. We call it termination because that's what most people think of, but it's not limited to that. We're going to be focusing mostly on 3 laws. Anybody care to guess what they are? Workers' compensation laws. FMLA, I heard FMLA. Somebody's looking at the screen. Okay. Now, before we begin, we need a little survey. Raise a hand. How many of you work for a company that has an employee? Well, you all do. All right. Workers' compensation law will be applicable to you. How many of you work for a company that has 4 employees? Oh, come on. 1, 2, 3, 4. You're 1. You have a boss. And there are always 2 bricklayers somewhere in the firm. If you've got 4, then the disability laws, the ADA and its Ohio version, are going to apply to you. Here's one question where maybe not everybody will raise their hand. How many of you work at an employer who has, counting all of your regular temps, count them, 50 or more? You will pay attention to the FMLA. Make certain that you included your regular temps in the position in your company. Let's talk first about the workers' compensation laws, 4123.90, quite often simply abbreviated as the 90 case for obvious reasons. There are 2 things that we want to talk about first. And the first one of those is certain conduct by an employee that generates protections for that employee. There's basically, rather straightforward. If you're an employee and you file a claim, that's a protected activity. If you're an employee and you institute a proceeding, or if you pursue a proceeding, you're protected. Those particular provisions of 90 have not received a lot of interpretation from the courts as to just what's the difference between filing a claim and instituting a proceeding. But let me ask you this: if you're a self-insured employer, have you ever heard of a self-insured complaint? What are you going to do with somebody who files a self-insured complaint against you? They've instituted a proceeding. You're going to deal with them carefully. There are other proceedings to institute. There are other proceedings to pursue. It's not just filing a claim. And it's not just an injured worker. Mary has a claim that the company is fighting tooth and nail. They must be represented by Bugby and Conkle. And Bob shows up to testify on Mary's behalf. Is Bob protected by 90? I can wait a long time for a solid answer. Yes, Bob's protected. Until an employee engages in one of these 4 protected behaviors, 90 simply does not apply. But as you can tell, it's not hard to engage in any one of these behaviors. Not hard at all. All right, well, the next part of the formula is prohibited employer conduct. Here's what the employees do to gain the protection. Here's what the employer does to put itself at risk. The obvious one, they fire people. But there are other, less obvious ways. You demote somebody. You know, if you're going to be the head of safety, and you walk around here so bad that you keep slipping and falling and having injuries yourself, I don't think that you should be the head of safety anymore. We probably ought to return you to your operator position. Any problems with that? 5 minutes ago I didn't think there was, but maybe now there is. You reassign somebody. This is not just reassigning jobs. Have you ever heard of reassigning somebody to a shift they did not necessarily want to be assigned to? If you haven't heard about that, God bless you, you're an innocent, you've never walked a day on the wrong side, but that happens, pardon me, I've heard of people doing that. Any kind of reassignment. And basically we summarize these all up by saying any kind of punitive action. Only our imagination prohibits us from saying, here's the complete list of punitive actions an employer can take. And may I also encourage you to recognize that punitive is from the eye of the beholder. What you think is a reasonable response could be viewed by an employee as punitive. Do you think that there is any definition available to us as to what punitive is? If you answered yes, you're wrong. There is no definition that we found yet that is workable. Now, just because we have an employee engaging in protected behavior and we have an employer who appears to have engaged in prohibited conduct does not necessarily mean that 90 has been violated. There must be a connection between the two, a causal connection. That word is not casual, that's causal, a causal connection. The employer's prohibited conduct was taken because of the employee engaging in protected behavior. These are the kind of things that not only keep me up at night, but unfortunately members of my family. What does the word because mean? Well, believe it or not, we don't know. It could mean but for, meaning that if this is the only reason, there was no other reason that this action was taken, there's nothing else that contributed to this, it was because of this action. There are United States Supreme Court decisions trying to tell us what the word because means in various federal statutes. We unfortunately do not have any Ohio cases telling us what because means in 90. But another possible meaning of the word because is that it's one of a number of substantial reasons. This is an employee with a long history of discipline, in addition to which their attendance is spotty, in addition to which they love to mouth off to the supervisor, in addition to which they have a really lousy job. Oh, and they filed a claim. We got a lot of reasons there. Somebody's going to argue, somebody who represents injured employees, that since one of those reasons is they filed a claim, that's enough because. And then finally, there's a lower standard that I think is very seldom used, but it's just that in the long list of reasons, it's kind of throw in. It really doesn't have any significance, but since I'm asked to give you a list of reasons, the first 98 reasons are related to performance, and the 99th reason is that they testified in behalf of Mary's claim. It's just not, there's not even the straw that broke the camel's back. It's just a matter of fact. It's out there. I hope you can see that each one of those different understandings of the word because connects the action of the employee to the action of the employer at different levels. Some of the connections are very strong. Some of the connections are very weak. Of such things are the sleepless nights made. How do we analyze this causal connection between them to try to figure out whether this is or is not because of? There are basically four areas that we're going to be looking at if this ever becomes an issue. And the first one is whether this particular employee who has been the recipient of this punitive action, what's their prior disciplinary record? I think you can imagine in your own mind that if we're talking about employee A, who's got this long list of prior disciplines dating all the way back to the beginning of last week, dating all the way back to the beginning of their employment, and on about a monthly basis, whenever there's a good sunny Friday during golf season, this employee has a stomach ache. I think it's coincidental, but it nevertheless happens. This is an employee with that kind of record. They get discharged. Another employee, under similar circumstances, has been here for 5 years, has never done anything, except that one lousy little thing where they filed a claim for statutory permanent disability. What was that phrase, Rob King? Statutory permanent total disability, was that the phrase? Sounds close, okay. Cut me some slack, I'm just an employment lawyer. That's the only thing they ever did, and they got fired the next day because, what was the reason that the employer gave? Well, after stammering and humming and nodding around, said, well, I'm an employer in an Ohio at an at-will employment state, so I just want to. That's not gonna fly. So prior disciplinary record is one of the things we look at when we're taking a look at the causal connection. The next one is do we have any existing policies? It's amazing how many times people find, or employers find something distasteful in the employee's behavior, but then doggone it, they just can't find where in the employee handbook they've said that that's something they don't want done. I feel every day that I've probably been around the barn of looking at employee handbooks so many times, I'll never be surprised at something I don't see in a handbook. And that's true for about 10 seconds. There's always something that appears to be missing. And so one of the things that becomes important in this discussion is, have you got something in the handbook that predates the filing of the claim? Not one that you filed up the morning after, but one that predates, that speaks to the employee's behavior. If you do, that's good. If you don't, let's move on. The third topic is very similar. It's your past practice. When other employees have behaved in the same or similar fashion, what has your response been? Has it been discharge? Has it been suspension? Has it been look the other way because I'm busy? Has anyone, pardon me, no show of hands, have you ever heard of a manager who looked the other way and did things because I'm pretty busy? Well, of course you did. Of course you do. It's the genesis of one of our principles in HR. Heard it earlier in Rob Solt's presentation, though he didn't use the phrase, where we're past practice. Practice is the conduct version of the handbook. The handbook is what you say your policies are, and the practice is what you do in terms of your policies. And so they are somewhat a mirror image of each other, but what you do, and more significantly in this discussion, what you have done in the past, is going to be a question. If it looks like this time around you've been a little more severe, the first 100 people who did that got a suspension. This one, who by the way happened to file a claim, got fired. Could there be a connection? That's going to be something that you'll have to struggle with. The final one, and I think this is it's the easiest one to identify, and it is probably the strongest one either way, and that's proximity in time. Is the punitive action about a half hour after the employer learned of the filing of the claim? Or is it 5 or 6 or 7 months down the road? The farther away the employer's conduct is to the employee's conduct, the less connection there is causally. Is there a magic time where you can say, okay, I'm counting my days until I can fire this SOB, because Tybalt said, if you do it inside blank number of days, it's a problem, but as soon as you get to blank plus 1 days, it's not? No. I would say this to you, if you get to a year, you're pretty safe. An awful lot happens in a year. But just, maybe I should say it to you the other way. If you're ready to fire after you open up the mail that brings the Freud to you, let's put some time between the opening of that letter and the writing of the discharge letter. Let's put at least, what do you say, a week or so or more, at least, please. Fram oil filter. You can pay me now. You can pay me later. Let's not write that letter too fast. There are a couple of procedural prerequisites before somebody can bring suit under 90. And then it's a both. You have to do both of these things. The first one is that there has to be a written notice to the employer where the employee or their representative claims that the punitive action violated 90. And then, if they're going to file a lawsuit, they must do it within 180 days. This has happened, and the statute allows it. The letter arrives on day 89, and the lawsuit arrives on day 91. It works. It's against the intent. The intent of the statute was to allow a period of time for the employer and the employee to work it out. It's intended to say, I was unaware, I didn't see this coming. Is there some resolution that we can reach without going to court? Whatever its intent was, it simply sits out there as a procedural prerequisite, and there is no requirement as to the gap between the two. I have not yet ever seen the suit come before the demand, the letter. I've read of a case where it happened, and that case got thrown out because it violated the intent. The intent is, let's have the letter first, then the lawsuit. But even if the letter's day 89 and the lawsuit's day 91, that's still the right sequencing. What are the remedies in a 90 case? They're rather limited, and that's something that we'll come back to in a moment or two. But if the employee has been discharged or maybe demoted to a lesser paying position, they get reinstated. Reinstated means restored to the position they held. So if it was a demotion, they're going to get that position back. If it was a discharge, they're going to get ordered back onto the payrolls with the lost wages if applicable, offset by any interim earnings they might have had, and then assuming that the next three words are not a non sequitur, reasonable attorney fees. We can all argue what reasonable means, and generally, if you have already lost the case and you have been found to be one of those nasty employers that takes punitive action, trust me, most judges will think that the word reasonable is a bigger number than you think it is. There are some special circumstances that can arise in a 90 case. I want to just touch on them real quickly. The first one we've mentioned a little bit before, and that is the connection here between the protected activity and the prohibited conduct. It almost goes without saying, doesn't it, that the activity, let me rephrase that, the conduct of the employee must come first. Then the response of the employer. We have a lawsuit that has given us what happens if the sequence gets wrong. The employer fires before the employee can file. Well, there's some good news and some bad news to that. This is a Ohio Supreme Court case of some years now, 4 or 5 years, where that's exactly what happened. The employee was in an accident, had a rather bad injury, got fired for violating safety rules, and then the next day, the employee filed their Freud. They filed a 90 case. The Supreme Court said, no, sequence is wrong. You do not have a claim under 90 because the activity could not have been because of the filing of the claim, because the claim hadn't been filed at the time of the firing. That's the good news. The bad news was we have what the Ohio Supreme Court calls the public policy tort. If you have been discharged in violation of a policy that is set forth clearly in either the statutes or the Constitution or the regulations of the various executive agencies of both the state of Ohio and the United States, it is against public policy to allow the employer to fire you and get away with it. And this particular employee's problem was that he got his sequencing wrong, so he couldn't bring an action under 90. But the good news for him, the bad news for the employer, was that the policy is violated because of the accident that the employer knew was going to generate a claim. We can't let this stand. Here's the bad news part of it. Public policy torts have compensatory damages. The embarrassment of being fired, the loss of lifestyle, the emotional distress, those are not in a 90 case. They are in a public policy tort case. So this is a good example of winning the battle and losing the war. Translation, if you ever know of somebody who wants to fire an employee because they filed a claim, because they are about to file a claim, tell them wait till they file the claim. There's another answer you could give them, but if they're hell-bent to fire, let's do the firing after the filing. Another circumstance that arises is that an employee is off on leave while the accident they had, for example, Archie, gets his legs severely crushed at the back of the trash truck. And he's off. Right from then until a long time later, he's off. And an investigation obviously could not be begun, let alone finished, before he began his leave. So he's off on leave while the investigation is being done. And the investigation finally comes to a conclusion. And in this case, I'm going to assume that the conclusion was, among other things, Archie had violated the no use of cell phone policy, which is a dischargeable offense, especially when taken into consideration of Archie's prior record. But Archie's on leave. I can't fire somebody who's on leave, can I? Yes, you can. Is it a little risky? No. Is it a lot risky? Yes. But if you have followed your own procedures, you have your history that this policy, in fact, with others, is a dischargeable offense, and the clouds part and shine on you. Archie admits that he was using the cell phone not once, but twice to plan the taking of a bike that he wasn't supposed to. You've got cause. And the fact that he's on leave is not a prohibition on your proceeding with the discharge. A lot of people think that once an employee goes off on workers' comp leave, they are sacrosanct, they are shrouded in all forms of protection, and that's not true. The other circumstance is that, well, we've got this attendance policy, and years ago I got here with trying to figure out whether this was a good excuse or that was a good excuse. I'm just not getting involved in is this an excused absence? It's just a no-fault policy. You're not here. An easily determined fact. Is Bob here? Let me look. Nope, Bob's not here. No fault attendance. Under workers' compensation laws, fine. There's a very specific Supreme Court case that's got a lot of years on it, because back in the 90s, that pretty much addressed that very question. The fact that somebody is off on a workers' comp leave gives them no extra protection for the simple fact that it's a workers' comp leave. It's their off work. So if you have a no-fault policy and you want to count their time off, you're good. Unless, there's always an unless. Unless you're one of the people who raised your hand when I said, have you got 50 or more employees counting all of your temporaries? And you know why that is. It's right up on the screen. Do you know why that is? A couple of you got it. FMLA says that if this is an FMLA leave, it cannot be used as an absence under a no-fault attendance policy. Now, there are a couple of ways it cannot be FMLA, and we'll get into those. In fact, why don't we go into the FMLA right now? This is going to be a very abbreviated presentation of the FMLA, which, of its own, will probably take all day to talk about. But we're going to talk again about, under the FMLA, what are the things that employers are prohibited from doing. You cannot interfere, you cannot restrain, you cannot deny FMLA rights. You can't discriminate or retaliate someone who uses their FMLA rights. And you also cannot discriminate against any person who opposes or complains of an act or unlawful. This is for another day. I don't know why the first two say that you can't treat employees this way, and the third one says you can't treat persons this way. I don't know what that means to say yet. That's not today's discussion either. But I will say it's a question in my mind. All right, one of the things that you heard in all of those was FMLA rights. You can't deny FMLA rights. You can't interfere with FMLA rights. But what in the world are the FMLA rights? There's a big bushel basket full of them. For our purposes, there are three. An unpaid leave for a serious health condition. Now I know that I've been told that this is a room of employer representatives. And so you may be a little hesitant to be too quick to say, well, that's a serious health condition. Well, that's not so serious. In fact, I might have even heard somebody just say, I came back from surgery after 1 week. That's not so serious. Well, good for you. Let me ask you about Archie, who had both legs crushed to the point where they're amputated above the knees. Does anybody think that that's not serious? Good, I should see no hands on that one. So Archie has a serious health condition. In addition to whatever else he might have, he has a serious health condition. And I'm going to assume that his employer has 70 employees. So he's got an FMLA right. 12 weeks in a year. I put quotes around that, but I think you all know that the year is something that can be defined a little bit differently depending on where you are. So right number one is to be on leave. Right number two is to return from that leave to whatever job I got available for you when you come back. Is anybody paying attention? That's not right. To the same position or its equivalent. If you get into the regs and try to figure out what's the difference between the same position and the way the Department of Labor defines what's an equivalent position, and if you come up with there's a difference, let me know. I can't find what the difference is. Let's just go with the same position. But now I'd rather have you on third shift rather than on first shift. That's right. No, same means, what do you think same means? Same. Same. What's it mean? Same. That's FMLA right number two. FMLA right number three, the continuation of group health coverage. What happens, however, if while Archie's off, continuing to get the benefit of the health insurance, he stops paying his share of the health insurance premium? Most employers, I don't even know, I think, it doesn't matter. Most employers have employees pay some part of the health insurance premium. Well, Archie says, you know, I ain't paying that. I'm not paying that. My lawyer tells me I don't have to pay that. What are you going to do about it? You're going to keep covering him because his right is to have the coverage, even if he doesn't pay for his part. Now, there's a so what down the road, a little further down the road. We're not going to talk about that today, but at the beginning, if he goes on an FMLA leave and stops paying his health insurance, don't you dare cancel him. You have a big problem if you do. All right, let's have a couple of tips about what to do with the FMLA. There's a very peculiar thing about the FMLA. It expires. It's not unpaid leave forever. It's 12 weeks in a year. What happens on the day after the end of 12 weeks? There's no more FMLA rights. We're done. Says the schemers in the crowd, of which I'm captain of the team. Maybe I want to turn this into an FMLA leave even if he didn't ask for it. So that asks the question, when does an FMLA leave begin? It begins when the employer says it begins, when they designate it as an FMLA leave, when you have sufficient information to know that this is a qualifying event under FMLA. We've already all failed to raise our hands when we were asked the question, is the loss of both legs above the knee a serious health condition? We all know that it is. We're all on notice then. From the moment the accident happened, Archie qualifies for FMLA leave. I'm going to go to my forms, my wage and hour form, I got it on the screen, my wage and hour form 382, my designation notice, and I'm going to designate your time off, Archie, you're on FMLA. Boom. We're on day one. I'm going to assume Archie has never used it before. You got 12 weeks, Archie. Now, some people might say, well, let's talk about that. There might be a reason to not designate, to not do that. And the reason would be that I'm going to have to, well, I'm at the bottom here. I'll start with the bottom. The reason I don't want to do this is I'm going to have to continue his health care. Because if it's an FMLA right, a leave, he's got what? FMLA rights. So I'm going to continue the health care. Why would I want to do this then? Well, the reason you would want to do it is that 12 weeks and 1 day later, the FMLA is gone. And we don't have to worry with that statute anymore. You'll have to make the decision. But may I ask you to give thought to that? I think almost by definition, and I think I will remove the word almost. By definition, if an employee is off on temporary total, they've got a serious health condition. Meets my definition. I can't hear you. Question, Do you have to be consistent in how you manage that? Remember that you cannot discriminate against people who use their FMLA rights. So if by consistent you mean, can I treat people who take the FMLA rights, can I treat them worse than I treat people who take a personal leave? No, that's discrimination. In the world of the lawyer, however, if you mean by, can I treat them better than I treat people who do not take an FMLA leave, the answer is yes. Discrimination in the mind of Congress means treating bad. It doesn't mean treating different. It means treating bad. Okay? Thank you. Jim. Wait a minute, that's Jim Sass. He'll go on forever. Somebody else. Jim. Say what? I'm going to restate your question, Jim, and if I restate it wrong, tell me. Jim's question is, what about if I post-date the claim a week or so back from when I learn about it? Is that about right? That gets into a slippery area. You can post-date. First off, we don't post-date. We date at a later time, okay? Let's get our vocabulary correct here. We date at a later time based on when it is we had sufficient knowledge on which to make our claim. It could happen that Archie's accident happened while I'm on vacation. I'm off somewhere doing something and I don't know anything about it till I come back. I'm going to give myself a nice, I took a month vacation. And so I didn't come back until a month later. That's when I learned about it. Combined with the fact that I was gone, I think you could date it at a later time. Archie, you have been on leave since the date of the accident, which we just learned about today. If, however, you know about it and you sit on it because you're busy or because you hadn't even thought about it, and then you're here today and you say, you know, somebody in January, I think I'm going to go back. Boy, I'm glad I came today because I heard what Tybo said and I'm going to go back, and that leave that started in January, I'm going to call it a FMLA leave, and there's only 2 weeks left. That ain't going to work either. Does that answer your question, Jim? There's another hand over here. Scott, Chris, Bob, Sam, what is your name? Chris.
So, an employee can, if they have a personal issue, they can take an FMLA leave. So, a personal medical condition. In this case, it's caused by it's a workplace injury, so they have a different claim. Can they reject the FMLA designation on it?
The question is, can an employee say, no, 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 I am not on FMLA. I didn't ask to be on FMLA leave. I don't want to be on FMLA leave. Take your designation notice and do some physically impossible things with it. That's a great question. The courts are having a hard time with it. There are 7 that have spoken to it. 6 have said, if the facts justify a leave, it is the employer's right to designate it FMLA. The 7th court, which sits in a state way to the west of us, whose name I won't mention, has said, no, 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 this is an employee rights statute. If the employee does not want to take FMLA leave, then the employee's rights rule. We're going to need some clarification. Our court, the 6th Circuit that sits in Cincinnati, has not spoken to that issue yet. I think, to me, it's a better read. Now, I do represent employers. I think the 6 have got it right, but it's an unresolved question. Thanks, Chris. Good question. Let's continue on. Another tip. As I mentioned, you can't count these absences under a no-fault attendance policy. My guess is that by now you know that so well you could tell me. What about a policy that I have in my handbook that says if you take a when you come and ask for a personal leave, and we'll grant it under certain circumstances, but while you're off on your leave, we will not have you doing any supplemental employment. No, 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 no. Leaves are for the reasons granted, not for purposes of employment. What if you find that while, what's our buddy's name? Archie. Archie's off there recuperating, but he's rented a van that he's got the configuration on it that he can drive it without his legs, and he's doing door-to-door sales, making some pocket change, but he's employed. And you've got this policy that says he can't. Can you fire him for that? Yes, everybody hesitates because it doesn't sound right, does it? Well, it goes back to the discrimination question. If other people on leaves, if people on leaves other than FMLA leaves are discharged for that, then you may discharge a person who violates that policy even though they are on an FMLA leave. Subpoint to that practice point. Call me first. Let's talk a little bit about that one. We'll do it, but we'll try to keep as many loose ends tight as we can. Last practice point here is that, well, this is again the situation. Give me the name. Archie. Archie is off work immediately, and I'm conducting this investigation into what happened. And I discover while after we've sent the designation notice already, my HR people are just a little too good. They send it out right away. I didn't finish my investigation. During my investigation, I discovered that he violated all these policies of mine. What do I do now? He's already on FMLA leave. What do you think? This again is a discrimination question. If Archie had been off, if people have been off on non-FMLA leaves, and while they're gone, you conduct an investigation that discovers grounds for termination, and you have terminated, you may do the same even though Archie's on an FMLA leave. Don't let FMLA intimidate you into silence. It is a strong employee rights statute, no doubt about it. But it's not everything. There's room to wiggle if you're the employer, and you know and you're prepared for it. How much more time did you want me to take, Greg? Jeez, I thought he said I was going to have more time. I've only been here 15 minutes? Crying out loud. I'm just going to sit here. Let's talk a little bit. Here's the concern that is becoming more and more prevalent in today's world, and that is that when you have an employee with a medical or mental condition that's wrapped up in this whole milieu of decision making, it's the age of the disability. It's a somewhat, I think, curious fact, but nevertheless a fact, that the Americans with Disabilities Act was signed into law by President George H.W. Bush. And the Americans with Disabilities Act, Amendment Act of 2008 was signed into law by President George W. Bush. They got they got the H out of it. No, they didn't. They put the H right back in it because, may I say to you in all candor, if you've got a condition that you've got a doctor treating you for, we're going to be able to make it into a disability. That's almost what Congress said. The purpose of this act in 2008 is to make it easier for people to obtain protection. Our primary object now is have those nasty people we call employers, they left the word nasty out, lived up to their obligations under the ADA. For the longest time, the question was, do you have a strong enough, a big enough impairment that you're disabled, but not so big an impairment that you can't do the job? An almost impossible burden for the plaintiffs to meet under the original law. We quickly run to the interactive process. An employee wants an accommodation of some kind. And today's predominant employer reaction is, tell me I'm wrong. That's right. Several of you in this room already have sat on the phone with me, and I can hear your eyes roll and your sigh go. I thought we were not supposed to discriminate, and now we are treating these people special. Because in this case, discrimination is not the test. In the disability law, it's accommodation, which is a fancy word for special treatment. So get over it. Yes, it's discrimination. You're treating people special because you have to comply with the law. And the best way to do that is through this interactive process, which is just talk to them. What's the problem What is it that you can't do? What is it that you think you need? Keeping in mind that what the employee wants is simply what the employee wants. Who is responsible for finally deciding what accommodation will be used? You are, with one restriction. The accommodation you pick has to work. It has to be effective. Example, very recent, I don't have time for examples. Meet me afterwards, I'll give you examples. How do you run this interactive process? Let me say that if you take it seriously, the rest of it's going to work its way out. This is the eye roll. This is the deep sigh on the other end of the phone. Do this. Get over that. You got to take this seriously. Then we had a case come out in September 30th of this year. Pardon me, of last year. Here we are in March. How can we have September 30th of this year? September 30th of 15, the employer lost $675,000 because it refused to talk. It said, you're not disabled, and even if you were, that accommodation I can't make, goodbye. They didn't even talk about it, and the Court of Appeals pretty much ended its decision right there. It took maybe 8 or 9 pages to tell us all the facts, but then it said, and the employer didn't even talk to the employee about the requested accommodation, therefore the employer loses. There should be fewer eye rolls and deep sighs now that you know that. Meet quickly. Consider a provisional accommodation. Usually the employee's thought of, here, this will work, it translates into my life, my employee life is going to be great now. I'm not going to have to work, and I'm going to get to set my own schedule, and I'm going to get to go on breaks when I want to because I have an accommodation that I need. Okay, maybe for a little while, that's okay, while we go through the process. Here's the one thing that everybody forgets. Follow up. It's 6 months later. It's a year later. It's later. 2 things change with time. Health conditions change. They might have healed. They might have got over it. Do you think they'll run into the office someday and say, Lord Almighty, I've been cured. I don't need the accommodation anymore. I bet they don't. So you follow up and say, you know, you look to be running the 50 in pretty good time lately. What 50 is that? From the door to your car at the end of the shift. Follow up. The other thing that happens with the passage of time, new technologies arrive. And what might not have been doable last year is old news this year. And how will you ever know that if you don't follow up? Greg's looking at me like I don't like him to look at me. So I'm going to stop. Greg, I need an accommodation. I need a little more time.
It would be an unreasonable.
Thank you very much.